but she had probably about a $40,000, $50,000 debt on the property, which I helped her pay off. I also had given her a 2015 Mercedes. She didn't like it, so we sold it. We got her a 2022 Kia Seltos. So that way, when we went and we had the prenuptial set or signed, we listed the bank accounts, her own bank accounts, I believe it was her own bank accounts that was listed in that, as well as the 2015 Mercedes. But at that time, we still had it. We hadn't sold it yet. And the Moscow property.
In English, I can read it, so maybe it will be easier. Your Honor, I understand what I have been informed. I cannot participate in the merits of case. However, I request permission to speak on procedural matters as they concern the legitimacy of the current hearing. Due to procedural violation that may affect the course of the case, and as the opportunity to speak in order to ensure the administration of justice and the legality of the process. Says, within 21 days after the court renders an opinion of the settlement agreement in place on the record, the moving party must submit a judgment order or motion settle a judgment order, unless the court has granted an extension. So court didn't grant any extension. And that means that plaintiff's attorney was required to submit a proposed order for the hearing on the 28th, within 21 days after the hearing. So that's supposed to be 21 of March. However, she failed to do so. So this block...
Let me stop you just a moment, okay?
Yes.
Again, this was noticed up for a hearing this coming Thursday, is my understanding. Hold on. Ms. Quist, are you in agreement that we just deal with this now?
Sure, absolutely. I want to get this done.
Okay, then go ahead, Ms. Gumaleva.
То есть, получается, мы сегодня проводим damages hearing, и потом в четверг мы проводим objection по приказу. Правильно я понимаю?
It's today we're doing only damaging hearing, and then Thursday will be, как вы сказали, последний object?
Приказ по слушанию 28-го.
Order of hearing on the 28th.
Okay. That's why I was asking Ms. Quist if she objected to dealing with that motion that is scheduled for Thursday today. And she said yes, or she doesn't object.
No, but on Thursday we scheduled motion to show cause. It's about plaintiff to...
Right. I think you have more than one motion.
Они незаконно опубликовали видео.
Happy to deal with that.
Анна. Незаконная публикация видео.
It's about illegal publishing video.
Right. I understand.
Yes.
I understand, but I thought we had more than one motion for Thursday.
Yes. Also, we have objections, but we cannot proceed this damages hearing if we don't have order, first of all. And second of all, I didn't have time because Mrs. Quiz didn't... She didn't, она не дала свой order, она не дала proposed order. И это было, скорее всего, сознательно и намеренно.
Because she didn't provide the order in the purpose.
Okay.
I didn't have time to fill my motion for reconsideration, and I feel это нарушает мои права.
Yeah, it's breaking her rules.
Okay, I understand. So we're going to go ahead and we're going to address that now. So go ahead, Ms. Gumaleva.
Это будет процедурно неправильно. Это будет ошибкой.
It would be a mistake in the procedure of the hearing, and it would be illegal.
All right, Ms. Gumaleva, continue. You started with the court rule, which I'm very familiar with. Did you have anything else you wanted to say on that issue?
Продолжайте.
Absolutely, yeah. I can say all everything what I am thinking about this issue. Can I speak? We can remove this objection to today. I wouldn't mind because that's me who wants this order become what's the word? Like я хочу, чтобы приказ уже вступил в силу, чтобы наконец-то подать свой motion for reconsideration. Просто давайте сперва здесь, я потом.
It's in her interest that this order will become start becoming legal, and that's her
As soon as it's possible. Yeah.
as soon as possible. Yes.
Yeah, это не я тянула с приказом. И это вообще не моя вина.
That was not her
Но
fault.
я с удовольствием сейчас I'm ready to say about objection. We can move it for today if you want.
Yeah, she's ready to continue.
Okay, that's fine.
Продолжайте читать.
Хорошо. So this так. Blocked my filing of my motion of for reconsideration as under rule 2119F. I cannot file such a motion until the entry of the order.
It starts with money, debt, and control. Right out of the gate, we hear testimony about tens of thousands of dollars tied to a Moscow property, debt that was allegedly paid down during the relationship.
Deciding the motion.
And Ms. Quist said she agrees. She does not disagree. She agrees with that.
Госпожа Квис согласилась с этим. Она не согласилась.
Но она не подала приказ.
But she did not
Почему?
have the order.
Если она согласна с этим, почему она не подала приказ вовремя? Это очень похоже на сознательную манипуляцию процессом.
If she agreed with that, why she did not file the order on time, and it looks like it was made on purpose.
Okay, a motion for reconsideration cannot be filed until an order is entered. So you are correct, and your timeline is preserved.
Yes.
Вы правы, и ваше время предусмотрено. Просто заявление не может быть подано, пока не вынесется приговор суда.
Okay.
Okay.
I have complied a meritorious defense and good cause as required MCR 3.2.210 and MCR 2.603D. And additionally, I have proven the extent of extrinsic and intrinsic fraud along with other errors made in the entry of default as required by MCR 2.613. And I have demonstrated palpable errors as outlined in 2.119F. Furthermore, I have gathered numerous 8 pieces of evidence showing what either my former attorney acted in the interests of the plaintiff or was completely incompetent and unable to provide with adequate defense. Я могу их сейчас дать суду.
Перечислить.
Вы
можете перечислить их.
Да, я могу их перечислить прямо сейчас, если необходимо. Но это займет какое-то время. Поэтому, если вы можете перевести, да, что.
If it's needed, she can list all that has been done, not in order by the plaintiff attorney.
My opinion, plaintiff's counsel did not submit the proposed order on time because that was her plan all along to accept the proposed order right at the damages hearing, or how it appears now with, как бы сказать, задним числом. Как сказать, задним числом?
But the date that was in the past.
Okay. And it's likely what she will attempt to push through this default judgment today, despite its contradicting MCR 3.210 B4A. And Mrs. Quist will likely claim what it was my fault the order was not signed, as I allegedly refused to sign the proposed order she sent to me. And this is exactly what she said. However, I have in my possession the proposed order, what she sent to me, and the proposed order, what she sent to the court. And that's completely different proposed orders. That's completely different documents. And this morning, I sent both of these both of these documents to the court. So, Your Honor, you can see and you can see what that's not the same document which she sent to me and which she sent to the court. That's completely different. And you can personally verify what they are different documents here. So the proposed order, as it was sent to the court, was never sent to me for approval. Never. It was simply entered as a contested motion, even though I was never given the physical opportunity to contest it. And in response to the first and only order sent to me for approval, I submitted my amendments, which I also sent to the court this morning. And I respectfully ask you if you can review these amendments and clarify whether I was incorrect or yeah. And would it have been procedurally correct if, in the court's view, for me to sign the order in the form in which it was sent to me by plaintiff's attorney? So I would like you to see it and to clarify it for me, if it's possible, please.
Ms. Quist.
Your Honor, I think you did state your basis at the beginning of this hearing, like I said, where I think we're all in agreement. The one issue appears to be that we stated that the court was fully apprised.
Objection, Your Honor. That's not right. That's not true.
Ms. Gubaleva, you've been
No,
able
that's
to speak.
not the
It's
truth.
her turn.
That's
It's
not
her
the truth.
turn.
Yes.
We have to follow the rules.
But what's the lie?
Ma'am, you can't. I'm going to mute you because I need to hear what Ms. Quist has to say. Go ahead, Ms. Quist.
Interested in getting the order entered. I think you stated the basis at the beginning of the hearing. The big objection from what I'm sifting through all these pleadings, the big objection is that we stated the court was fully apprised of the premises, which we always do because both counsel argued on behalf of their clients. I declined to remove that because words have meaning, and I know that she is setting this up for an appeal. So I am being very careful about it. Having said that, I think we can all agree on defendant's motion to set aside the default was denied. Defendant is entitled to a hearing on damages. The plaintiff bears the burden of proof that the proposed division is equitable under the court rules. Defendant may not participate in the hearing. Defendant is not allowed to engage in discovery and remains in default, and this hearing was scheduled for today. I think we're all in agreement on that. I would like to move this case forward. And I have a concern about removing a sentence that states that you were apprised by counsel of the situation at an oral argument and in pleadings. So I have an objection to that. I have a case up on appeal right now and words have meaning. So that was my objection. That's why we couldn't get the order entered.
Right, Ms. Gubaleva, is that correct? Is that what you're objecting to?
The defendant believes the delay robbed her of a legal opportunity, while the court prioritizes efficiency. From here on out, there's no rewind, only consequences.
Can I finish let me finish my question first?
Sure.
Okay. So is your objection, is it to that phrase that the court was fully advised in the premises?
My objection. No, that's not an only one.
Okay. So can you very briefly and very short, clearly say what exactly in the proposed order you're objecting to?
Скажите коротко, чем вы не согласны?
In other words, let me make it even clearer. What in the proposed order is something that I did not say in the transcript?
В этом приказе какая часть вы не согласны?
I would like to ask the court to clarify whether defendants dependent.
No. I need you to answer my question. What
Sure.
in the proposed order does not reflect what I said in
So
the transcript?
right now, Mrs. Chris said what I я могу участвовать. Это то, что она сейчас, что я не могу участвовать. Однако в ордере этого не написано. Там написано, что я могу участвовать. И если я действительно могу участвовать в damages hearing, я не против. Но это процессуальная ошибка. То есть мы не можем вести приказ, который противоречит транскрипту. А он противоречит транскрипту. И кроме...
Stop and let her translate, okay?
Говорите, пожалуйста, маленькими частями, я не могу так.
Смотрите, значит, проблема в том, что она написала, что я могу участвовать в этих hearings. А мне на суде не дали в них участвовать.
The problem is that she said she can be participating in this order, but she got paperwork that says she's not allowed to participate in this order.
I wouldn't mind. I mean, that's fine, but that's not correct. And second...
All right, just a minute. I'm looking at the last page of the transcript. Let's see. I'll even say what page it is.
Она смотрит последнюю страницу.
I can actually send it to you.
No. Don't send me anything, okay?
No,
that's not appropriate. Okay, just a minute. Okay. Look at page 9 of the transcript.
Yes.
9-ю страницу.
And it says, and I quote, "My understanding of the case law is it's plaintiff's burden to show that the proposed division is equitable and that the defendant really has it. They're entitled to attend, but they cannot participate."
Yes, that's what I'm talking about. But according to Mrs. Quist, the proposed order, I can participate, and this is not correct.
Your Honor, I just read from her order right here.
Oh, ma'am, just a minute. Just
What I read to you in court just now is her proposed order. We accept and agree to that. We accept that. I just objected to that one sentence being taken out because both counsel argued. But what I read to you just now is from her order, and we accept that.
okay. Then
That's it.
that order, I'll sign that.
Thank you.
I'm signing your proposed order, Ms. Gumaleva.
Она посылает вам приказ.
Что?
Она посылает вам сейчас подписанный приказ.
It is, Your Honor, it's the 42525 order. It's the one I just read.
Да, я хотела сказать, что в моем proposed order такого не было. У меня мой ордер прямо по тексту транскрипта. У меня не было таких слов. Может судья посмотреть, если она хочет.
She telling that in her proposed order she did not have this, and the judge can check and verify that she did not have it in her proposed order.
I just read it to you, Your Honor. We can email it to you. It's got her signature on it.
Okay.
So that
Okay. So at this point, then we have an order.
That she had over in Russia, as well as I had bought her a 2015 Mercedes that she didn't like, and we sold it and got a Kia Seltos.
And I'm just going to follow up on that since we just touched on the subject.
Ms. Quist, hold on. Mr. Vera, could you repeat what you said and just slow down a little bit? Because I think it's the speed at which everyone is talking that's causing the difficulty.
I understand, Your Honor. And Deanna's English is better than what she wants to say. But anyways, during that time frame, she left to go back to Moscow to finish renovation of her place. I had already finished paying the apartment off. I had already bought about 70 to 80% of the materials needed. When she went back, there was other things that she needed to buy to finish a kitchen and bathroom. and find labor.
Is
So
it something that I need to interpret for her, or we can continue?
Ms. Gumaleva, do you understand?
Вы понимаете? She's saying something I cannot hear.
Can you give a thumbs up or a thumbs down?
Вы понимаете, скажите так или нет? I guess she understood.
Okay.
So, with that being said, I that's hers. It was she originally had bought it prior to the marriage, but she had probably about a $40,000, $50,000 debt on the property, which I helped her pay off. I also had given her a 2015 Mercedes. She didn't like it, so we sold it. We got her a 2022 Kia Seltos. So that way, when we went and we had the prenuptial set or signed, we listed the bank accounts, her own bank accounts, I believe it was her own bank accounts that was listed in that, as well as the 2015 Mercedes. But at that time, we still had it. We hadn't sold it yet, and the Moscow property.
The judge makes it clear the damages hearing will proceed today, regardless of any pending motion for reconsideration. Efficiency over delay.
I have a question for you, Mr. Vera. Just since you just brought up the Mercedes, you sold it and purchased a Kia for Ms. Gomleva.
Yes, I did, a Kia Seltos.
What happened to that car?
I moved my daughter and I used it to move, and we were parked on the side of the street, and somebody that had been drinking either passed out or was on their phone, and they ran into the back end of the Seltos, totaling it.
Is there
The vehicle sat from October till this happened December, I believe it was December 8th of 2024. The vehicle sat, and I would occasionally drive it because it's not good to let a car sit for over a year and not driving it.
and was the car insured?
Yes, I did all the insurance. And it was actually titled in both of our names because Deanna didn't go through and get a Michigan license in order to continue insurance. So I had to be the one to insure the vehicle. As a matter of fact, I think they took her off the insurance because she had been here since 2022, late fall of 2022, November,
Mr.
I
Vera,
believe.
can you stop a minute?
Yeah.
Ms. O'Mealy, can you translate? I saw a hand.
Yes. Which part is Diana did not understood because she raised her hand like before? Can she speak? I cannot hear her.
Да, после того, как он сказал про машину, что он что-то там про insurance, вот с этого момента
Вы поняли, что произошло с автомобилем, что она стояла в стороне возле дома все это время, пока вас не было? Вы поняли, да?
это его сказки, да.
Вы хотите про иншуранс именно уточнить, да?
Да, что после этого, что он сказал?
She wants to know what Mr. Vera said about insurance part.
Okay. All right. Mr. Vera, could you slow down and repeat the part about the insurance?
In America, we need to have our vehicles insured in case someone hits us or in case the vehicle is damaged. It protects us as individuals in the car. If we're critically injured, it also protects the car being replaced. I paid for the insurance. I continue to pay for the insurance all through the marriage, which isn't an issue. So that way the vehicle would be properly covered during this time.
Он платил и платит за страховку этой машины, и это для него не проблема, потому чтобы этот автомобиль был покрыт страховкой на случай, если будет какой-то авария или кто-то будет в машине. Continue.
Just a quick question, Mr. Vera.
Mhm.
How long have you known Diana Gomleva?
How long have I known her?
Yes.
I met her December 13th or 14th of 2020.
Have you ever had a problem communicating with her because of the
No.
language barrier?
No.
Thank you. Back to the car. So it was insured at the time it was hit.
Yes, it was.
Who was it insured by?
It was by insured by Hanover Citizens.
Okay. And what have they done in regard to the car?
It's a total loss. At the time, I wasn't sure what the loss was. So, when Deanna got upset about the car being wrecked, I had indicated that there was about $17,000 worth of damage to the vehicle. And I had offered to give her that or get her another vehicle to replace of close to the same value or the similar value or similar vehicle. Of course, she got upset and said I did it on purpose, which I don't know how that's possible. But it was total. The Citizen Hanover has been sending me numerous emails because they need to have the title signed off. But because both of it's not.
Mr. Vetter, can you back up and slow down, please?
Okay, sorry. The Hanover has been asking me to provide a signed title back to them so they can close the case on the insurance claim. The title is, instead of it being Christian or Deanna, it reads Christian and Deanna. So therefore, I have to either have the court allow me to sign the title in behalf of Deanna, but it needs to be both our signatures in order for the case to be closed. They found out that they agreed to pay $25,000 for the damage of the vehicle.
And my understanding, Mr. Vera, is that the check will be.
She has her hands raised. So back up a little bit, Mr. Vera.
I can repeat everything he's just said about.
Okay, good. All right, thank you.
Он утверждает, что когда машина была повреждена, ее нужно было ремонтировать, для ремонта нужно было 17 тысяч. Поэтому он эту машину отдал страховой компании. И для того, чтобы отдать страховой компании техпаспорт, на техпаспорте должна была быть ваша подпись. Но так как на техпаспорте стояло его и ваше имя, ему нужно было разрешение из суда, чтобы поставить подпись за вас. Continue. I was just interpreting about the signature and the title that you had to do.
Which I have not done.
Those names.
Okay.
Yeah, which I have not done yet. So.
Okay.
Он еще не поставил эту подпись.
And the $25,000 check will be given to Ms. Gumliva, correct?
That's correct, because I bought the vehicle for her as a gift. And on January 3rd, I told her that I would either try to, at the time, I thought it was only $17,000. Now, since that.
No children. No shared assets beyond what's already been addressed. The picture forming is one of a short marriage, heavy documentation, and a prenup doing exactly what it was designed to do.
Last communication between the two of us via WhatsApp, I found out that that they were going to total the vehicle and they were going to issue a check for, I believe it's $25,000. It might be a couple dollars more, but it's the $25,000 is the value that they say the vehicle is worth. And therefore, because I bought it as a gift for her, she deserves that.
That's consistent with the prenuptial agreement, given that it was a car. It was a Mercedes that she chose to sell. Correct? And buy a Kia.
That's correct.
Okay. So
I'm not sure she understood you, Ms. Quist. Could you say it again and slow down?
Okay. So given that the two of you decided to sell the Mercedes and purchase a Kia.
Так как вы оба приняли решение продать Mercedes и купить Kia.
That is consistent with the prenuptial agreement, the judgment, she will receive a $25,000 check.
Это сходится с заявлением, которое было принято, что вы получите 25 тысяч чек, так как это был ваш подарок.
Mr. Vera, has Ms. Gumliva collected her personal belongings from your house here in Michigan?
No, actually, that's what sparred all this fighting in court was that She wanted to come get her car and her items at the house. And that's when I said that if she's welcome to come get the items in the house, but there's an issue. And that's when I explained about the car. At no given point was she even concerned that myself and my daughter were almost hit by this guy. We were 25 yards from the car. Right away, it was more of a concern that I did this to hurt her and to get back at her, versus any concern on any safety. But when the issue arose that the car wouldn't be there, that's when all this spiraled down the ugly slope that it's at.
And you will have, and if we can get a court order to sign the title, then you will turn over a check for $25,000 to Ms. Gumliba, correct?
That's correct. I think I also indicated that I could send it to your office and you could
Absolutely fine. Absolutely fine. I'm happy to be the person.
But she's welcome to all her things. It's just I can send them to her.
Are they valid?
Oh yeah. I mean, Deanna didn't. I treated Deanna good. I mean, she Saint Laurent leather coat, Burberry trench, Christian Louboutin shoes. She's got a lot of nice. I bet just in those 3 items, it's close to $10,000.
And
they're all hers.
They're all hers. They're all packaged and ready for her, and they're in exactly the same state as she left them.
As of just recently, I moved them out of my closet into the spare bedroom closet, but they're still on hangers. They need to be packed up and sent. But I would be willing to send those to wherever she's living, or if she wants to come and pack them up herself and grab them, which I don't know why she would want that. I can make arrangements for her to meet Alba and them at the house. But I would prefer that maybe I don't know. It might be easier for her to look at them and pack them. So.
Okay.
She raised her hand. Oh.
She seems to be okay.
Okay.
Besides what we have described, was there any joint property that the two of you purchased during the 8 months that you lived together as husband and wife?
No.
Mr. Vera.
As a matter of fact, at that given point in time, I had sold my company, and I wasn't working the way that I should because the company wasn't paying for what they were supposed to, and I ended up having to take them to litigation. So therefore, I didn't work, and I haven't worked. So therefore, I haven't been able to really acquire any more assets after that time. So,
and looking at the judgment of divorce, in your opinion, is it consistent with the prenuptial agreement, given what we've talked about today, which I knew we would have to discuss?
Yes.
Okay. And do you consider the terms of the judgment fair and equitable?
Yes.
Okay. And at the time of the signing of the prenuptial agreement, did you and Ms. Gumliba consider the terms of the prenuptial agreement to be fair and equitable?
Yes. Stephen was given the opportunity to speak with counsel, Audra McClure, which she never reached out to be able to make sure that all this was fair for her.
And I have reviewed that email, Mr. Vera, so she did not follow up. I'm going to ask you a couple of questions in regard to, it's really just procedural, but it's jurisdictional also. Were you a resident of the state of Michigan for 180 days prior to the filing of the complaint for divorce?
Yes.
Were you a resident of Kent County for 10 days prior to the marriage?
Yes.
And the filing of the, okay. Has there been a breakdown of the marital relationship to the extent that there is no reasonable possibility of reconciliation?
Yes, we tried counseling, it didn't work. So I just want Deanna to be happy. You know, I want her to move forward in life. She's smart, she's intelligent, she's beautiful. She can acquire anything that she wants that she sets her mind to. I want her to move forward. I couldn't make her happy. I don't want her to continue to live.
The courtroom doesn't erupt. There's no dramatic outburst, just a quiet acknowledgement that this chapter is closed. The court now has what it needs. Orders are signed. Testimony is entered. And unless reconsideration changes everything, the path forward is clear. In this courtroom, Procedure 1 and emotion never stood a chance.